Welcome to the In-Rem Podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, good morning, everybody. Welcome to the show. Today, our topic is how to deal with difficult homeowners associations. I'm Andy Fowler. I'm here with Sean St. Clair. If you're new to the show, give us a like. Subscribe to our channel, whether it be on Facebook or YouTube. We're on multiple platforms for you, and your likes and shares help us and help us grow our channel. We appreciate that. With that, Sean, if you would give us our legal update.
So the legal update today is I wanted to discuss the recent settlement with the FTC and Open Door. So most investors out there and our listeners probably saw that the FTC settled with Open Door, whereby Open Door is going to pay $62 million as a result of the FTC's claim that Open Door misled consumers.
Now, the FTC being the Federal Trade Commission?
Federal Trade Commission, yes. So they've basically said, hey, Open Door, throughout the years, you've misled consumers in your advertising, in basically stating that as a seller, you would net more using Open Door than through a traditional sale. And so apparently complaints were made, FTC investigated, they ran the numbers and determined, or alleged anyway, that that statement was not true, and that most sellers would net more through a traditional sale than selling through Open Door. So what does this have to do with investors, right? Because Open Door is, an iBuyer, an investor, but also, a traditional real estate brokerage. I mean, they had a broker's license and were, licensed, at least here in Arizona, and I believe other states. So what does that have to do with investors? Well, I think that settlement is kind of should provide investors with just a little bit of caution to say, okay, what am I doing when I'm out there looking to, buy and sell real estate as an investor? Because what's an investor trying to do, especially when they're trying to buy? Trying to find a deal, right? They're trying to buy it for less than, what the property could be sold for through a traditional sale, or, less than fair market value, because you wouldn't be a good investor if you were always paying fair market value and couldn't then, sell your property for a profit. But the key is, what are you representing? What are you telling the seller, telling the consumer about, your offer, about your process, about, what you're providing to them in the way of value? And you need to make sure that, you're properly stating and disclosing the information regarding the transaction, and that you're not misrepresenting anything, or even concealing, what we define in the law as material information or basic information that you would expect someone to know. So in Arizona, we have disclosure laws now for investors, and those kick in September 1st. And we've gone over them in the past, which basically those disclosure laws require that an investor who intends to assign their contractual interest to a third party, that investor disclose to the seller that they plan to wholesale the property, that they plan to assign their interest in the property, their not interest in the property, their contractual interest in the property, to a third party and for profit. And that's what the law requires. And that's what needs to be disclosed in the purchase contract. So I think the FTC matter and case is just another kind of word of caution to investors that, there are regulators out there looking to protect the seller, looking to protect the consumer. and you don't want to end up on their radar by making misstatements or misrepresentations in your transactions.
Well, I think the temptation as a small time investor is to be happy about this in the sense that it's taken a big player or knocked out or hit hard a big player that is a competitor of yours in the space, but that's just a big player that's easy for a big agency like the Federal Trade Commission to go after. They actually just represent a practice that's happening within the industry, but happening on a much bigger level. So it really should come as more of a concern, you're saying, than a celebration.
Well, I think that from an investor standpoint, there are some benefits when you have a large conglomerate out there that you know you're competing with, and maybe you believe that they're not engaging in appropriate business practices, and to see actual consequences for that. But you also have to kind of look in the mirror and say, okay, am I doing it right? Am I avoiding these types of issues? And investors should. I mean, that's the bottom line. They should be um, looking to make a profit, looking to properly invest, but do so ethically and legally.
Sure. All right. Well, thank you for that legal update. With that, we're going to go into our topic for today. We're talking about homeowners associations. We've all dealt with them on any number of levels. Almost all of us, and probably most of the people listening to this program, have dealt with homeowners associations, either currently or at some point in their life. And if you're a real estate investor and you've got ideas about what you want to do with your property and how you want to turn that into income, or whatever you want to do with that investment, you're going to have limitations or likely have limitations with the subject homeowners association. So today with us, we have Jonathan Dessaules with the Dessaules Law Group, who is, among other things, an attorney that focuses on homeowners associations. Jonathan, thanks so much for being with us.
Thanks. Thanks.
Yeah, Jonathan, tell us about Dessaules Law Group.
Well, we are a 10-person law firm. We handle primarily HOA matters, although not exclusively. But I mean, most of our work, about 3/4 of it probably, is HOA related in some. But we tend to do a laboring or of the representing homeowners in Arizona in HOA disputes.
Tell us a little bit about your practice specifically. What states are you licensed to practice in?
I'm licensed to practice in Arizona, New Jersey, only because I've never figured out how to quit New Jersey. I am inactive in Pennsylvania.
Now, as one of the few attorneys in Arizona who represents homeowners, or makes it kind of their goal to represent homeowners against HOAs, how'd you become involved in that practice area?
Entirely accidentally. First, went out on my own as uh, I had a partner. Then we went out on our own in war, and someone walked in the door and had a dispute with the homeowners association. I had never before. They had a dispute with the property manager before, and then one person after another kept coming into my office. Somehow I was the magnet that a lot of people came to, and I recognized, and I and I through that I also perceived a need there. I mean, the homeowners associations have a number of law firms. Homeowners, not so much.
Sure. So let's talk about some of the homeowners association issues, and we wanted to focus on ones we know that real estate investors that we deal with are running into quite a bit. But one of the big disputes between HOAs and homeowners is the attempt by certain HOAs to eliminate short-term vacation rentals in their communities by trying to amend the CC&Rs. How easy is it for the HOA to amend their CC&Rs in this regard to try to impact or stave off vacation rentals?
Well, today it's a lot harder this time last year. Arizona Supreme Court recently weighed in and sort of reject a majority of your neighbors can sit there and decide whether and how you can use your property if you want to use it for short-term rental, long-term rental. If the association wants to include a new restriction, they need to get everyone's approval generally, unless there's something in the document that's very likely at some point you're going to wake up one day and not have the right to.
So, Jonathan, you're referring to the Callaway decision, right, with the Arizona Supreme Court?
I am.
Now,
And yeah,
go ahead. I don't mean to cut you off.
edit that out. I'm sure you'll edit that out. Go ahead. I didn't mean to step over your step.
No problem. So the Callaway decision was that didn't involve short-term vacation rentals, though, right?
But the rationale actually fairly accurately to this desire rentals in communities that have no rental restrictions whatsoever. I mean, that's one of the associations that are waking up one day and the board says, these short-term, let's go ahead and ban them. And if you as a homeowner or an investor bought property of renting it, and you wake up one day and your neighbors or even the supermajority of your neighbors said, yeah, we don't want you to rent anymore. I mean, that defeat purchase the property.
So, what are some other HOA issues that you regularly deal with in your practice, other than dealing with these issues involving short-term rentals and things like that? Tell us about some of the other things. Do you deal with open meeting violations?
Open meeting violations are fairly common, especially in HOA. Board members have been on there for a long time. It seems to me that some equate the length of time they're on the board with almost just the fiat. So a lot of boards will sit there and meet in private and decisions, and then you as a homeowner find out after the fact. But the law says that everything. There are some exceptions, but contracts and those run-of-the-mill things are not things that can be done secretly or by email. Consent vote of the board. The whole purpose of having transparency and open meeting violations defeat that transparency.
Yeah, it's my understanding that pretty much anything that's decided by the board outside of certain confidential information, like financial information regarding a homeowner, or financial information regarding an employee of the association, or attorney-client privilege stuff. But for the most part, everything else is supposed to be done via open meetings and not by, email, or even, some informal in-person, meeting in some homeowners or board members' house. But it seems like a lot of HOAs don't follow that practice. Is that what you see as well?
Far fewer HOAs on most of them violate them in some ways, and sometimes it's unintentional. Some are, in an elevator together and they start talking and that's a violation. Sometimes they sit down and they say in an email, let's pass this resolution. And sometimes you're in an open meeting, they go to executive session, and then they start talking executive session. You know, hiring, which contractor to hire, which bid to pick, whether there should be changes to the landscaping requirements. All those things are things that own it, and they don't get to participate when you have open meeting violations.
What role do you think that property managers or HOA managers, association managers play in these types of violations?
I think the role they should play is to police the board members and remind them happen during. This is something that should happen during a meeting. More often than not, they are charged, whether intentionally or not, sending emails to board members, and then there are discussions that take place. And when a community manager should, rarely does, should say, this is something that needs to be discussed in the.
One of the things that I found in, dealing with these HOAs is the lack of knowledge and experience of these association managers. And I think it comes back to the fact that there is no licensing of an association manager, right? I mean,
Right.
somebody could decide tomorrow with no HOA experience that they're going to form an LLC and call it, Association Management Plus. And next thing you know, they're out there saying, hey, I can manage your HOA, yet they know nothing about that process. They know nothing about the laws, and there's no regulation. There's nobody saying, oh yeah, you had to pass a test. You have to show, a certain level of competence. And yet, the HOA is looking to them for guidance. I mean, has that been your experience as well?
Well, keep in mind, these community managers manage millions of dollars. Any other industry where you're entrusting millions of dollars in asset, a minimum they would be licensed. They're not. The Arizona legislature had the opportunity funded, and every once in a while it comes back in front of them. Should we license? I mean, realtors are required to be licensed. Property managers that are not HOAs are required to be licensed. Everyone's required to be licensed except someone who's, managing an HOA.
Jonathan, what are you seeing in terms of HOA overreach during close of escrow? And let me give you a specific example. And we see this and are interested to kind of get your take and what you see. But submitting payoff statements to escrow agents with outstanding penalties listed. Do you see that issue?
Well, and there's two. The first one is submitting payoff statements that have fines on them that to a judgment, and they're using the escrow process in order to compel an owner to that they may dispute. And of course, you're sitting at the closing table. What seller in there say, wait a minute, I need to go challenge those $2,000 in fines first. The other side of that coin is from the buyer's perspective. The buyer, there's a closing. The buyer's told, okay, here you go. Here's the property. There's no violation. The buyer gets a letter from the association saying, hey, that tree that's been out violates the CC&Rs, or that paint color violates, some violation close of escrow, and doesn't, the buyer is now having to spend dollars to rectify a situation they didn't cause, and they were told by the association or expressly there are no violations there.
Yeah, so I want to jump back to.
Go ahead.
I want to jump back to the. So those are two things that happen all the time where they jump in there and insert themselves into the close of escrow, which Arizona law allows and provides. In fact, you're supposed to have certain disclosures from the HOA, and they're to provide them. But so to back up on the fines, including the fines, so if I understand correctly, an HOA can only have a lien for assessments pursuant to the CC&Rs. And if there's fines, like leaving your trash can out after 5 p.m., $50 here, $50 there type of thing. But if the HOA has those types of penalties or fines, that the only way that they can have a lien against the property is if they reduce those amounts to a judgment. Just having those numbers out there in a computer system does not allow the HOA to receive those from a close of escrow or receive those as a lien against the property, because at that point, all they are a number in a computer, right? I mean, that they're nothing more than that.
And in many cases, those numbers weren't communicated. I have a case where a woman was fined $150,000 for short-term rental violations. She didn't know about it until she happened to just request a copy of $150,000 in fines on her account.
And of course, there's a whole statutory procedure in place on providing notice of those. And you even have a right to contest it and request certain information from the association with respect to those fines. So she wasn't receiving any notices whatsoever. It was just all of a sudden, boom.
That fine was issued on a single day. That was one fine for $150,000 issued on a single day, encompassing alleged weeks and weeks and weeks of rental violation actually unenforceable. Those fines have now grown to $300,000.
So the statute says that fines have to be reasonable. So who makes the determination of reasonableness?
Well, ultimately, a court should, and several courts have. There's a number of factors that weigh into reasonably. The way the associations and the community managers treat it, especially at close of escrow, when the association says, well, these fines are reasonable, these violations exist, so we're going to go ahead and the onus is then on the seller to go to court and say, and that's just the way that the system has developed, and it's not fair to the owners. It's slanted in favor of the HOA. So if you're sitting there at a closing table and you're selling your property and you're going to make a bunch of money to do all that, you're not going to look at the couple $100 in fines, all that. You might no one wants to go hire a lawyer to challenge fines and pay that lawyer far more than what's there are making out.
So who knows what our real estate market's going to do right now? But when the short sale era was happening, I know I was involved in foreclosure and short sale consultations and advice and things like that. And one of the things that would come up on a regular basis would be these payoffs by these HOAs, where they've tacked on all of these, fines and penalties and stuff like that. Well, of course, it's last minute, like you said. And what's been obtained already is lender approval. And the lender has said, well, as long as we net this amount of money, we're good. Well, then they go and request the payoff from the HOA. And sure enough, the HOA has, $3 or $4 grand worth of fines and penalties, which is going to then put the lender's number out of whack, and nobody wants to go back for lender approval. And so, who's eating it? The real estate licensee is, cutting their commission or doing whatever to try to make it happen. And, I've had some that are willing to, fight that, or work with their sellers to employ, an attorney to fight that. Have you had the opportunity to deal with those issues? And if so, kind of, how do you attack them if you have a little bit of time to try to convince the escrow agent and or the title company that, hey, you cannot claim these at close of escrow?
Well, unfortunately, the escrow company is very receptive to that. I mean, they hear that all the time. Hey, that charge is not valid. So generally, my advice to people is agree to pay it. Make sure there's a note in the file saying that, look, you're paying it under protest because you're going to lose the set, and then we go back later and then try to the benefit to owners in that situation is there's no judgment. There's a line item fine in a ledger somewhere that's never been changed, and then the question is, well, what do you have in terms of violation? Third violation. I mean, there's plenty of grounds to challenge it. You can't do it when escrow is 30 days away or less.
Yeah, I see your point. Do you think though that there's any legal theory that maybe could be argued to say, hey, you guys are improperly clouding our title and you have damages, under, Arizona law for, slander of title or something along those lines? Because that's essentially what they're doing, right? They're saying we have a lien when there is no lien. And they're placing a cloud, on title and claiming an interest in property that doesn't exist.
Yeah, but they're not recording they're not recording. If they took those fines and they reduced them to a lien and they recorded the lien, that what they're doing here is, they're not reducing it to a lien because they know better. So they're acting the same way that they otherwise would if they had a lien. Could that be a slander of title? Potentially. I mean, it's a contract with the association at a minimum, and there's other unjust enrichment. I mean, who knows why fines are put on. Sometimes we see selective enforcement. You're being fined for something that your next door neighbor has the idea he has never received so much as a violation notice. So there's plenty of just not in the expedited time frame of a closing.
Yeah. Well, and it could even be intentional interference with a contractual relationship, right? I mean, you basically are interfering with the ability of the buyer and seller to, close escrow because you're demanding amounts that you're not entitled to receive. So that's another possibility, maybe leverage some negotiation on, from the HOA. Let's talk about the situation that you mentioned where they failed to disclose known violations at close of escrow. What is the duty of the HOA to disclose existing violations on a property that's subject to sale?
Well, the statute's a little bit less than association has an obligation to identify violations it knows about. It responds, when they issue a violation to the new buyer, they usually say, well, we didn't see that violation. But I think that, in order to give effect to that requirement, it's not just simply known violations. It has to, if the associate that there's a violation there and they become aware of it because they walk by that property every day, they have an obligation to report that violation. I mean, a lot of times these violations are not there's not some easy corner saying, okay, I'm just going to wait till the new buyer comes in. A lot of what happens is, which is management companies, the new management company comes in and looks at the property and says, hey, did you know that they painted their house the wrong color? And then all of a sudden the new buyer is getting violations from their, and that's where a lot of these disputes arise.
Yeah. And we've actually seen it where a couple of instances where the HOA sends the notice and the new owner contacts the HOA or the management company and says, wait a minute, what's this about? And they say, oh, well, we told the prior owner and send a notice out to the prior owner that there's a violation. And then they go and they pull their disclosure packet from the HOA. And of course, there's no mention of it, which is just a complete egregious, willful violation of the statute. So in that case, I mean, assuming you have that type of evidence, where you can get that, former letter violation notice or letter, painting the house is a perfect example where they sent out to the, homeowner and said, hey, you need to paint your house. And the homeowner blows them off, sells the property. They don't disclose that the house needs to be painted. And then they come to the new owner and say, hey, your house needs to be painted. And the new owner said, well, what's this about? And then of course, that's when it came to light that, they had notified the prior owner. In that case, what's the remedy available to a new owner in that situation?
You eventually need to get that violation is not, you can't be fined. And unfortunately, you either have to association to sue you for that, or you file a declaratory judgment action saying, alone, tell them that this violation existed. And it's not just simply even if it's a violation in the pay. If the association, I mean, these some of these associations I understand are thousands of members, but some of them are, and they know the violations, and the fact of the matter is people don't receive violation notices because the association or the board doesn't. They only issue the violations to the new person. Maybe they don't like the new buyer, or maybe there's been a change on the board, and they want to go ahead and now enforce these violations. And there's also, I mean, one argument available to the new buyers is how long has this thing been out there? At some point, the association sits on its hands, not be allowed to go after those violations.
Well, let's talk about that. So, in Arizona, there's a 6-year statute of limitations for breach of a written contract. So, let's say there's an open and obvious violation, a known violation, a structure built, a shed, for example, is a good example of one where there's a shed that exists. You can see it. Anybody walks by the house can look over the fence, see the top of the shed, know it's there. And all of a sudden, 3 owners later, and 10 years have gone by and the new owner is getting a violation notice. Is that something that would be barred by the statute of limitations and unenforceable by the association?
Yes. So with whether it's the 6-year statute of limitations or whether you can actually argue that it's because it's not an action. It's not an action for a debt. Your statute applies for an action for an indebtedness. Arguably, it's a shorter statute of limitations, but under your fact scenario, I think it's very you waited too long. You sat on your rights. You didn't do anything for more than too late, and we see that a lot.
Yeah, and we actually had a case along those lines where it was a structure built on the property, and we were able to obtain aerial photos and send it off to the HOA and say, hey, this thing's been there for 10 years. Look at the aerial photos. And of course they were date stamped, simply just from the assessor's website, pretty simple. And we sent that off. Yeah. And, to the HOA's credit and to the attorney for the HOA, one of the prominent law firms that represent HOAs, they came back and said, you know what, you're right. And there is no violation, which I had to commend that attorney because I don't see that type of cooperation very much from HOA attorneys. What about you?
Given the number of those now and the length of time the violations have existed, no, I don't see that level of cooperation. Every once in a while, it's hopeless. But I got, I had a similar case where the requirement was you have to plant 2 trees in the front yard. and my client, 15 plus years ago, took out the trees, and they've had no trees in the front. And the association, my client buys it, and then the association steps in and says, "Hey, tree rule." And so we presented them with aerial photos, and they said, "Well, the aerial photos show there's tree. Aerial photos are picking up the neighbor's trees that were hanging over the property." So, but ultimately, you got two options. You either wait longer, and the longer you wait with some of these violations, the stronger your case becomes.
Jonathan, this is a real estate investor podcast, or the law for the real estate investor. So a lot of the folks listening have bought a property. They're looking to resell it, depending on the market dynamics, or they're looking to lease it. What are you seeing, or are you still seeing HOA regulations prohibiting things like flags, for sale sign, for lease signs?
Haven't really seen much action lately. As far as the flags go, the statute in Arizona says what kind of flags you can fly. I have had cases where flags are different flags, or I want to fly my Trump flag, or I want to fly my anti-matter flag, my anti-Antifa flag. I mean, most of these associations, the rules are fairly simple. The law is fairly simple. As far as for sale and for lease signs, haven't seen much of that either, because most of the associations say you can have them. They just limit the size of them, which they can do under the law.
What about issues of selective enforcement? I imagine you might see this. You're doing a VRBO. It's technically allowed under the HOA, but gosh darn it, some neighbors just don't like the fact that it's being rented out to vacation seekers, and HOAs are run by a community of people, right? And sometimes they're not always fair. And so what kind of issues do you run into in terms of selective enforcement?
I think every case has selective enforcement argument, because board members are human. Board members don't like to impose fines and penalties and violations on their friends. So and where you see this a lot, although is usually like in a on street or in lot car there, you have board members, owners who parked their cars for years, a new, and in the case of some of your clients, some of their tenants, and they want to park their car on their driveway. Novel concept. The association says, no, you can't do that. And then the person looks around and says, well, everyone else is parking their car. We are now enforcing that rule. After years of not enforcing it, we're now enforcing that rule. So, yeah.
So what is the law on selective enforcement? And, I've argued it here or there, and I don't know, I've never really found much traction with it, even though I know it exists and there's plenty of case law, especially outside of Arizona, on the issue. But what is the law? Where are we at on that here in Arizona?
Well, Arizona homeowners have a right to be treated uniformly and equally. And if they're not, that's my claim. The question really is, and where you see where selective enforcement claims fail a lot, violations, and say, well, because my neighbor is violating that provision, my violation should be excused as well. What the law, you look at the violation, and is that violation being selectively enforced against some people but not others? And the way you prove it, unfortunately, it costs money. You gotta walk the community. You gotta identify, get the records from the association, saying what has been done about those violations. It's a lot of work that's required, and sometimes sometimes it's just not. It's just hard to prove, and it's an expensive argument to make.
So when we talk and use the term selective enforcement, what you're saying is it's not selectively enforcing different provisions of the CC&Rs. It's selectively enforcing one particular provision against one homeowner and not another. Is that when we talk about selective enforcement, that's really the definition that we need to use?
Right. That's correct. You can't defend a violation by saying that your neighbor has his garbage can out all hours of the day. Selective enforcement would be, hey, there's a blue house, a blue house, a blue house, and a blue house. I want to paint my house the same color, and the association comes in and says, no, you can't paint your house that color. That would violate the.
Right. So it's basically enforcing one portion or one clause of the CC&Rs against one owner and not the other. But if the HOA decides, oh, well, we're not going to get into, let's say, encroachment issues between two homeowners, even though the CC&Rs clearly prohibit, one homeowner from encroaching on another. We're not going to get involved in that because that's a, neighbor dispute, but we are going to enforce the trash can regulation. That's not really selective enforcement. That's just the HOA utilizing their discretion on, what provisions they're going to, handle. But if your friend leaves their trash can out and you never find them, and yet you're finding other homeowners within the community for leaving their trash cans out, then you probably have an issue.
Yes, that's a fair statement.
What about the submittal and then unreasonable denial of architectural plans? You've got somebody who's wanting to build or whatever else. Is the analysis the same as to selective enforcement, kind of a fairness thing, or how do they treat unreasonable denial of plans?
Well, first you got to prove that it's unreasonable. There's some interesting issues with respect to what you can and what you can't deny in our lines that are adopted, conflict with the CC&Rs or impose greater restrictions. My architectural plan, is valid under the CC&R. The problem with the denial of architectural plans, of course, proving that it's unreasonable. And one way to prove it's unreasonable is what I want every other property or in these other following properties. And a lot of what you see, I want a wrought iron fence, and they say, well, we only have block wall properties that have wrought iron fences. Why are you not giving it to me? All of that goes into the mixing pot, and it goes to a judge, and the judge gets to decide what's unreasonable.
How does the same analysis apply to the issuances of notice and fines, the reasonableness of it?
Well, they have to issue notifications, and they have to give you notice of fines, and if they don't, that is just simply about violations and fines. Reasonableness can be: is there a fine policy? Has that fine policy properly adopted? Has it been published to the members? How do you impose a fine against someone for not, for keeping the trash can out if they didn't have notice of what that? So the amount of the fine, the frequency of the fine, and keep in mind the purpose of a fine: compliance with the CC&Rs. So if you're issuing hundreds and hundreds and hundreds, but the person is not complying, how is that fine reasonable? There are fines are of the of HOA law that there's no end to why it's unreasonable.
Jonathan, let's say that a homeowner does receive a notice of violation, whether it is in conjunction with a fine or just simply, hey, look, you've left your trash can out, or there's something on your property that's in violation. If you don't fix it in the next, however long, we're going to start fining you, et cetera. What are the rights of a homeowner once they receive that notice?
Well, the first thing they should do before they even consider their rights is continue to pay your who receive what they believe is an invest. Say, well, I'm just not going to pay my assessments, and that'll teach them a lesson, and that's the wrong approach. First of all, you have a right to request records from the association. That includes but records for other people's accounts. And what I generally tell people when they have a violation letter, I say, walk the community, find other houses where that same violation exists. Request the records that say what violations were issued, whether there was approval. You have the right to challenge the fine. You have the right to not pay the fine. And what I do right to make sure that your payments are applied to your assessments. And a lot of what happens fine, and your assessments are due on the first of the month, and you paid on the 30th of the month before. Some associations that will take that payment and apply it to the fine. So one thing, when you receive a fine, always respond back to it. Always respond back to it and say the law allows you the right to ask who noticed the violation, the process I followed to cure that violation, what was the date of the violation, and a couple other things. And if the association doesn't give you that information, it cannot collect that further including to incur attorney's fees until they give you that information.
Right. And to just highlight something that you said there, as far as the information you're entitled to receive, you are entitled to receive the name of the person who witnessed the violation. Sometimes that could be the community manager that they'll list. But if a neighbor is saying, oh, look at this, problem over here on this property, and they're the ones that report the violation, that is subject to being learned by the other owner, right? There's no anonymous complaints technically in the HOA world. So if you're going to report your neighbor, you better be prepared that your neighbor's going to find out that you're the one reporting it.
Yeah, although the way they get around it a lot of cases is they encourage the violation himself. Now, if my neighbor reports a violation, picks up the phone or says to the president, hey, I got a violation next door to me, and the president sends out the community mail, there's a pretty good chance that no one is ever going to out the neighbor as the person violation. That they'll say the community manager saw it.
Oh, isn't that? I mean, to me, that seems like, wait a minute. The statute requires that you provide the person who witnessed the violation and the date of the violation. Wouldn't that be the actual homeowner and the date that they reported it?
Unless the violation's ongoing. I agree with you. A lot of these cases, a lot of people, claim, and often rightly so, my neighbor's bullying me, my neighbor's picking on me, my neighbor's calling these violations. That's but a lot of times you don't see the level of cooperation from the association that you would expect. To discovery, and then you do get a copy of the questions. Well, what's the remedy for that violation? I mean, the association has now lied to you, violated the law, but there's unfortunately nothing built into the law that gives you a
Yeah, so there's no remedy, right? Now you
right.
do have the right.
The best you could argue is that the statute requires who reported me. You didn't tell me that, therefore you're not allowed to you're not allowed to charge attorney's fees. But it's not as crystal clear as
right. And now let's say a homeowner thinks that their neighbor was the one reporting them. So they submit and they request that information. The HOA says, oh, well, it was the property manager on this date. And you're like, oh yeah, you're not telling me the truth. So in that case, there's a statute that would allow a homeowner to request records from the HOA, and they could specify in that records request that they want all communications by, any homeowner to the board regarding their property, and the HOA would have to disclose that. So if it was sent by, a written communication, that's something that the HOA would have to provide, correct?
You would think so. Get those in a lot of times you don't get those in discovery. I mean, a lot of cases, the association just says, well, we're not going to provide those. And then, so then we file the lawsuit. Well, we're not going to comply with your records request because you have a lawsuit out there. Playing this game where you're, having subpoena records. We just had to serve 12 subpoena members in a case because the association's attorneys refused to ask, and that was a Fair Housing Act case, and the records that came in were, it's pretty clear why someone didn't want to produce them. Not the lawyer, I'm saying. The client apparently made that decision for them. We're not going to give you those records.
Right. Well, let's talk about HOA attorneys and attorneys that represent HOAs. There's, 4 or 5 of them here in Arizona. How have you found working with them? In my experience, we have some good ones who, when they're on the other side, I'm like, oh, we can come to some reasonable conclusion. But then, other times I'm like, oh, well, that firm's over there and they are going to take the HOA line at all costs, even if it's unreasonable. And, even if the HOA is violating the statutes, they're going to defend them to the, hilt, and there's nothing we can do about it. Have you found kind of the same thing?
I have some with it. And sometimes sometimes it's even broken down within a firm. There are some law firms that I have trouble with one person. I will call someone else at the firm and say, hey, can you intervene on this for me? And it's all about connections. And I mean, I'm kind of fortunate in that, too, just about every HOA law firm out there in Arizona, I actually count those people as close friends now.
Yeah, right. Yeah.
It's taken a while, but and a lot of them have, they've over the years, and I think things are generally better now than they were 10 years ago. But there are still some very big bad apples out there. Shouldn't be practicing law, probably.
Well, and that's really what you were saying about, having friends and collegiality with opposing counsel. I mean, that's really how it should be, right? I mean, we all work within a certain set of facts and, a certain set of statutes and cases. And, at the end of the day, why we are adversaries on a case, there's no reason not to, try to stay within those bounds and not, always just toe the hard line when that there's a problem, and try to figure out, how to work it out and resolve it. So I'm glad that you're able to establish those types of relationships, because that's, obviously beneficial to your clients to have those in place.
Jonathan, I wanted to ask, what research should an investor or buyer, what research should and can they do regarding a community before they buy?
Well, the first thing I would do is I'd go to the courts and see how many times have they been sued, how many times have they sued. The more times the association's name pops up in the Justice Court or the Superior Court record and the Department of Real Estate, I mean, that should be a red flag for that community. They should sit down and read the CC&Rs, and they should also sit down and, association ask for access to it. Ask for the seller's credentials to log in and go through all the governing documents and whatnot. and read the meeting minutes, because a lot of times in the meeting there's dysfunction at that association. You generally can't being invited, but if there's drama in that association in the minute entries, in the meeting minutes.
Good
the
stuff.
other way to go is also look at the, at the county recorder's office, because a lot of times, you might not pull up anything of liens. One of the more interesting facets of the HOA law is they have for assessments, but for some reason, and they go ahead and they record liens anyway. Why? Well, because it increases the amount of collect against you, because, hey, we spent a couple $100 recording this lien. But those liens will also give you an indication we're just simply not paying their dues.
Well, Jonathan, we really appreciate you being on the episode. Tell our listeners where they can find you.
You can find our website, www.dessaules.com. So call 602-274-2360. I'm happy to talk whatever issues they might have, HOA or otherwise.
That's really great. We really appreciate your time. It's been really informative. I look forward to seeing you again, Jonathan.
Thanks. I got to figure out there's leave.
Thanks, Jonathan.
All right. With that, everybody, that is our episode for today. Join us next week. We're talking about the Investor's Guide to Language in Lending Instruments. Our guest is Augie Panev. Look forward to seeing you next time.
Have a good day, everyone.